is a consultative forum. Therefore, on the training, we are seeking your expertise, your knowledge, your contributions in undertaking a very important step, a very important project to us as an organization and to our community in Rwanda. And therefore, wish that you participate as much as possible in this important event. I would like to thank the government of Rwanda for the support, for the collaboration that they have given us as Rwanda Bridges to Justice.
I think that this project is very interesting. We have 3 organizations that are coming together in the implementation of this project. We have the Rwanda Bridges to Justice, Dignity in Detention, and International Bridges to Justice. These are organizations that are well established. They have expertise which is complementary to each other, and I think they have really excellent know-how and services that are involved.
The government of the Republic of Rwanda recognizes the need to ensure that the way in which the criminal justice system deals with its citizens demonstrates respect for their fundamental rights and for the rule of law. In conclusion, I would like to thank Rwanda Bridges to Justice and Dignity in Detention for their support towards Rwanda's quest of access to justice and the rule of law. I pray close support and collaboration in the developing and giving a service to our people.
The first right that a suspect has is to be to be informed of the charges that he is being accused of or is being suspect to have committed. The right to be informed about the charges.
Accused is still has the human dignity.
The key question here is, how do public prosecutors understand their role in the pretrials? Because most of the time, and this actually I can say that it's just a widespread practice, that public prosecutors, whenever they go in a criminal trial, they seem to request the court to detain the person, to pronounce that. Yet, from the law books and the codes, they have that power whenever there is no charge or when they have no substantial evidence to request the release of the suspect before even going to court.
Sometimes you can go at the police station as a lawyer and you request your client, but the police can tell you, we are still in investigation, you can come tomorrow after tomorrow, you cannot meet with him today.
Totally, the prosecution believes in presumption of innocence, and we believe in the liberty of suspects or even the accused when they reach that phase.
Another thing, I will always, to each and every question that have been raised by the participants, I will always come back to the issue of having a legal counsel. If you want to promote the rights of the accused, make sure that every person accused in criminal justice has a legal counsel.
We have realized that mental health issues in prison is reality and a priority. From evidence-based, on 20 years working in prisons, and the recent research conducted by DIDE, Dignity in Detention, our institution has committed to help the detainees to recover. Mental health is not a privilege.
Agaciro k'umugororwa, agaciro k'umuntu ufunze, agaciro k'umufungwa. Mais quand on parle d'inéquilibre institutionnel, c'est impliquer tout le staff de RCS dans la prise en charge du détenu. Donc, à partir du directeur de la prison jusqu'à à la personne qui est là au gate, donc au gardien qui est à la porte. Tout le monde a été ou sera formé sur la prise en charge en santé mentale.
The crime can be judged, punished, if you want to call it that way, but the prisoner himself can be rehabilitated and he can be a sane, productive citizen of our nation.
So the early access to a lawyer by an accused, particularly at the time of arrest, can make a huge difference. It could prevent or reduce abuse, potential abuse by the police. It could prevent wrongful charge. It could prevent prolonged detention before the trial. And it could even prevent wrongful conviction. So a series of violations can be prevented if there is a proper. Now, when you go to ask what does it mean by effective, I mean the competent, committed counsel.
ikibazo cyiza ko cyo kugira ikiganiro nk'iki ngiki kubera ko u Rwanda mu rugendo rugenze uyu munsi twakwisanzura tukavuga ati twatanga ubuhamya kandi ubuhamya bwiza bugaragaza urugendo igihugu kigenze ndetse tukanishimira ko hari naho dutandukaniye n'ibyo mugenzi wanjye amaze gusobanura uko bigenda mu bindi bihugu biri mu nzira y'amajyambere.
Abana bahabwa abavoka mu rukiko rwisumbuye akaburanirwa n'umugabo, yajurira high court akaburanirwa n'umugore. Ibyo twahoze tuvuga bya trauma nyakubahwa meti, ibyo bituma bitraumatiza abana.
Bivuze rero iyo warahiye nk'umuavoka mu ndahiro naho bavuga ko harimo obligation bavuga défendre en âme et conscience.
So I think we identified a number of problems, and I thought we also shared some solutions. What we're trying to do through this project is to go into more practical solutions stage by stage and see how we could make them systematic solutions in our criminal justice system. The key aspect here is participation and collaboration, and we expect you to continuously actively participate in this process, because at the end, this is what we're trying to do is not just a project. I think projects has a very limited kind of connotation that is from one time to another point. What we are trying to do is to start a process of finding solutions to challenges and to see how we could collectively implement them, and at the end, our justice system and the people of Rwanda will benefit in the long run. So I'm very hopeful that we would go there, because I see that all of you are here has very positive intentions towards implementing change. With that words, I want to thank you and for coming here, and wish you would be with us next few years through the process to complete what we have started today. Thank you.